representing the spike increase and decrease and the forward and backward acceleration that the tractor sustains at the time of this violent impact. At this time, as the cab shakes, that is when Averett's tractor and trailer was being slammed into as a result of Phillips rear-ending the Welch vehicle at 63 miles per hour. Again, because Amber was maintaining an appropriate following distance, even though she was violently rear-ended and lurched forward several feet, she was able to avoid rear-ending the flatbed tractor and trailer that were directly in front of her. This video proves that at all times, Amber was paying attention to the road and traffic conditions in front of her. She was responding to the road and traffic conditions in front of her. She was maintaining a proper following distance to the road and traffic conditions in front of her. And lastly, this video proves that at no point in time did Amber ever apply her brakes in a dramatic, sudden, or unexpected manner. Rather, as the graph demonstrates from the brake line representing the speed of the tractor, it is a continual and gradual decrease over a period of 24 seconds. This video demonstrates that plaintiffs and interveners have no evidence that Averett or Amber breached a duty of care and or that any actions or inactions on their behalf proximately caused the accident and or the resulting injuries. In addition, plaintiffs and interveners' own liability expert, Lou Grill, prepared a 30-page report in relation to this accident after reviewing the documents and information provided to him. Nowhere in the 30-page report of plaintiffs and interveners' own liability expert does he ever point to any action or inaction on behalf of Averett or Amber in connection to this accident. Rather, in fact, Mr. Grill places 100% of the fault or blame for this accident on CNA Transport and its driver, Mr. Phillips. In addition, in response to our motion for summary judgment, Lou Grill prepared an affidavit supporting plaintiffs and interveners' response. Again, nowhere in the affidavit prepared by Lou Grill does he point to any actions or inactions on behalf of Averett or Amber that caused and or contributed to the accident or the resulting injuries. Rather, Your Honor, Lou Grill points to some discrepancies in the timekeeping records of the pre-trip and post-trip inspections recorded by Amber Isaacs in the logs. However, this is a red herring and irrelevant argument and discrepancy because there is no causal connection that has been demonstrated or evidence showing that these discrepancies and Amber's logs breached a duty of care and or proximately caused the accident and or the resulting injuries. Because the evidence negates two of the three necessary elements for a negligence cause of action, plaintiffs and interveners' claims must fail and defendant's motion must be granted. Specifically, plaintiffs have offered no evidence of cause in fact that any act or omission by Averett or Amber was a substantial factor in bringing about both the plaintiffs and the interveners' sustained injuries. They have simply failed to raise a genuine issue of material fact supported by evidence with regard to the two elements, breach and proximate cause. In turn, we are asking that this court grant this motion for summary judgment.
Thank you, Ms. Horvath. Mr. Mina, do you want to go first?
Yes, Your Honor. Thank you very much. To begin, Your Honor, we'd just like to discuss the standard for MSJ. As the court is well aware, and Ms. Gorbach correctly stated, they have the duty to disprove at least one element of the plaintiff's cause of action or plead or conclusively prove all the elements of affirmative defense. Obviously, this motion, we're talking about disproving at least one of the elements. Once that occurs, the plaintiff has to present evidence that raises a genuine issue of material fact. And a genuine issue of material fact is evidence that rises to the level that would enable reasonable and fair-minded people to differ in their conclusions. It should be noted that the courts are required to review the evidence submitted by the non-movement in the light most favorable to the non-moving party. And excuse the cat in the background. One other note, Judge, is, and this is more in their reply brief, but I figured it would be a pertinent place to put this in, is the defendants have essentially attempted to shift the burden for the plaintiffs in this matter. As we said, the burden is on the defendants for this summary judgment. The burden is obviously on the plaintiffs at trial, but there is a clear and distinct difference between the burdens from MSJ and from trial. All we have to do here today, Judge, is show that there's a genuine issue of material fact. We don't have to prove our case. That should be left for the jury. So to address one more thing, Judge, the majority of the case law that the defendants have cited for their contentions on proximate cause, which we'll discuss here in a second, all of them actually deal with an appeal after a verdict, not appeal after summary judgment was granted. So all of the case law that they've cited really is irrelevant when it comes to our conversation here today discussing this motion for summary judgment. So to discuss their issues specifically, Judge, when it comes to general negligence, ordinary negligence, there is two things that we have, two things that have been raised by the defendants in our causes of action. One is that they believe Ms. Amber Isaacs was not driving too slowly and did not fail to take evasive action. However, if you look at our response, Judge, on page 21, the case law is clear that drivers on in the roads of the state of Texas have a duty to keep a proper lookout, encompassing the duty to observe in a careful and intelligent manner traffic and general situations in the city, including speed and proximity of other vehicles, as well as the rules of the road and common experience. In this case, Judge, that's exactly what we're talking about. The video that Ms. Gorbach showed you actually proves that there is a genuine issue of material fact in this case. The failure to keep a proper lookout can be a proximate cause of an accident where the motorist should have seen something in time to avoid it by evasive action, but failed to do that. In this case, Judge, Ms. Isaacs testified during her deposition that prior to the crash, she saw the CNA 18-wheeler traveling at a high rate of speed behind her. Prior to the crash, she saw that he was driving too fast for the conditions, given the construction. Prior to the crash, she saw that he would not be able to stop his vehicle prior to impact. Prior to the crash, she saw that the decedent's vehicle, our clients, the interveners and the plaintiffs, was directly behind her 18-wheeler and in front of the CNA 18-wheeler. She saw that she was traveling at a low rate of speed, but not at a complete stop. After she noticed the 18-wheeler behind her would not be able to stop, she did not speed up her vehicle. She did not move over to the left lane. She did not move over to the right lane. Both of those things, all three of those things could have occurred based on the video that was just shown to you, Judge. Those are things that could have been done to avoid this crash, not the crash between CNA and interveners and plaintiffs, but the collision between the plaintiff's vehicle and the Averitt vehicle. Those are things that could have been done. They were not done. And to prove that a little bit further, Judge, during the video that was just shown to you, it specifically shows that there was plenty of room in front of her right before the crash. She actually slowed her vehicle even further down right before the crash. Presumably, she looked behind her and saw the crash happening, took her foot off of the accelerator, but as the video showed, she did not have her foot on the brake, which means that her brakes would not have been illuminated, which means the interveners would not have seen that her brakes would have been illuminated as she was slowing down even further. Additionally, it shows that the flatbed in front of her, even going as slow as they were, right after the crash, the flatbed moved over into the right hand, into the shoulder. So even going that slow, the argument could be made that by defendants that they didn't have enough time because it's a big heavy truck and they can't move over that quickly. That's completely disproven by the video that was shown to you, Judge. So when it comes to a genuine issue of material fact, we think that a jury should be able to decide whether Ms. Isaacs actually took the proper evasive action, if any, which she didn't, and could have lessened the blow, could have, our clients could have survived this crash. But that's something that should be decided by the jury, not through a summary judgment motion. We've presented a genuine issue of material fact on that issue, and we think that the court should deny the issue, deny the summary judgment on that issue specifically. When it comes to the logs, again, Judge, we briefed this extensively in our response. In fact, the portion of this of the response related to this issue is about 11 pages long. When it comes to the logs, DOT requires several things of commercial vehicle drivers. One of them is that they accurately denote their time on duty, off duty, in the sleeper berth, whatever the case may be, but they have to accurately denote that time. During Ms. Isaacs' deposition, she testified on multiple occasions that she failed to do that. Specifically, she said that she accidentally forgot to push the button on the Qualcomm system that would actually start the timer for on-duty status. However, when you look at the way she testified, she started her pre-trip inspection, forgot to press the button, and went, oops, I forgot to press the button, crawls back in the cab, pushes the button, and continues on her pre-trip. The Qualcomm system itself, Your Honor, has the ability to be edited. The driver can edit it, Averitt can edit it. Whoever has access to the Qualcomm system can edit the system, can edit the logs. Instead of going back and editing those logs like Ms. Isaacs should have done, knowing that she had not properly logged her on-duty time, she went ahead and instead confirmed those logs. By doing that, Judge, she specifically, knowingly, and intentionally falsified her logs. And I know Ms. Gorbach is going to say that this is not a big issue because we're talking about seconds, minutes, that sort of thing. However, the fact of the matter is that Lou Grill, plaintiff and intervener's expert, testified during his affidavit, which by the way, he has not been deposed yet. That deposition is scheduled for the next couple of weeks. But during his affidavit, he said that if you have improper logs, you shouldn't be on the road, period. So the fact that Ms. Isaacs was on the road specifically raises a genuine issue of material fact as to the cause of action that we're bringing for general negligence. Let's see. When it comes to proximate cause, which seems to be the biggest crux for the defendants in this case, as far as the majority of what they'll be arguing, it's universally held that proximate cause is generally a question of fact that should be left to the jury. That's statewide. All courts pretty much agree on that. The only time that it should not be left to the jury is when it is established as a matter of law that the reasonable minds could not arrive at a different conclusion. So again, we're talking about genuine issue material fact. The cause and fact means that the act or omission was a substantial factor in bringing about the injury. That's a key word, and something the judge, the court should recognize in this case is an injury. It's not the accident. And in their reply brief, the defendants kind of cast this off as minutia, but if you look at the pattern jury charge, there are two instructions for proximate cause. One is for injury and one is for incident or accident. There is a distinction, and there's a reason for that distinction. When it comes to foreseeability, the actor or person of ordinary intelligence should have anticipated the danger that his negligent act created for others. Again, if we go back to her testimony, excuse me, Ms. Isaacs testified that she saw the 18-wheeler coming at a high rate of speed. She actually ended up slowing down even further before the crash. She did not have her brakes illuminated. She did not take evasive action. She did not speed up to try to lessen the blow of this at all. These are all genuine issues of material fact that go to the proximate cause in this issue. So again, if we're specifically talking about genuine issue of material fact, we're not talking about the burden of trial. The plaintiffs and interveners have met that burden. One of the issues that was raised in there, I'm trying to be all inclusive, even though this is briefed in our response. One of the issues briefed was negligence per se, and as the court will recognize in our response, we concede that all of the negligence per se statutes that were cited were not proper for negligence per se, except for one. And that one is 454.401 of the Texas Transportation Code, which is related to the reckless driving. When it comes to negligence per se, you have to have a different standard than the common law standard of care, ordinary prudent standard of care. Excuse me. For reckless driving, the standard of care is willful and wanton disregard for the safety of persons and property. That is a different standard of care when it comes to the ordinary prudent person. That means that it is viable under negligence per se. Defendants have not cited any case that says that it is not viable under negligence per se. And it should be noted that defendants did not actually challenge the factual allegations with regard to our negligence per se issues. They only challenged the legality of it. So I'm sorry, Judge. This hurricane coming in is pushing all kinds of stuff in the air. Anyways, now, when it comes to direct negligence, the defendants actually disproved their allegations in their reply brief. Specifically, they claimed that direct negligence cannot be brought if the defendant company accepts respondeat superior liability. That is true for general negligence. However, in the defendant's own brief, the case law that they cite to, the Russell case, which is actually a Dallas Court of Appeals case from 2002, specifically states that where the plaintiff has alleged ordinary negligence against the driver and gross negligence against the owner for entrusting his vehicle to a reckless or incompetent driver, the negligent entrustment cause of action would be an independent and separate ground of recovery against the owner for exemplary damages. In other words, Judge, we have alleged gross negligence in this case. The gross negligence is based on negligent entrustment, negligent hiring, negligent supervision, negligent retention. We provided enough evidence, more than a genuine issue of material fact, on each one of those causes of action. So when it comes to the direct negligence as to Averett, it must go forward because we have alleged gross negligence as well. If you'd like, Judge, I can kind of rehash what we have in our response as far as the factual basis for why we think there's a genuine issue of material fact on both gross negligence for Isaacs and for Averett. It's up to you, Judge. I'm happy to do it, but it's all in our briefing.
No, I don't need any more. Thank you.
Thank you, Judge.
Mr. Finley?
Yes, Your Honor, and I'll keep this brief. I know we've heard a lot of information so far. Just to make clear, I just want to make 2 points that to add on to what Mr. Mina stated earlier. Is first of all, the video that we're watching, Your Honor, of course, that's the video in the front. We heard a lot of arguments as to what this video shows and how it shows how great she was doing driving. All of those are great arguments, and they'd be great arguments for an opening statement. They're not proper for a summary judgment. And the reason is this: we have clear as day admissions from the driver herself about what was going on behind her. And it's page 22 of our briefing, but she testified to that she saw this car coming behind her. She saw the 18-wheeler traveling at a high rate of speed. She knew it was a problem. She knew that there was going to be a wreck, and she didn't do anything. And the reason why that's important, Your Honor, is the video I just watched from Mrs. Gorbach. They touted how great a job their driver did in slowing down and not rear-ending the flatbed trailer in front of her. If you look at that video, the flatbed trailer in front of her did exactly what you're supposed to do. It veered off to the shoulder of the highway. And that's what our allegation is. Had Mrs. Averett done that on the day of the incident, then our client would not have been in the position they were in. Which brings me to my next point, which is proximate cause, which stated, as the court knows from handling many cases and many jury charge conferences, there can be more than one proximate cause in any case. It's the proximate cause resulting in injury. Our clients, one of them was decapitated as a result of the Averett trailer. Certainly, there is a genuine issue of fact to where the jury can decide, had she actually pulled over to the shoulder of the highway, our client would not have been decapitated by being pushed underneath this trailer. So that's our first point, Your Honor. These are all arguments that a jury should decide. The evidence is there, and it certainly meets the burden required by the courts to let reasonable minds on a jury decide. And if we don't prove that, once the court hears all the evidence, they can move for a directed verdict at that time, or there's several other avenues available. But the evidence at this stage is all of there by her own testimony when she stated the left shoulder and the right shoulder were both unoccupied, and she could have moved in either direction after she saw this 18-wheeler barreling towards her. It's that simple, Your Honor. The other portion I wanted to mention was she testified unequivocally. It's page 19 of our brief, page 178 of her deposition, that the 8 days leading up to this incident, that she had been in violation of her federal regulations. Under the federal motor carrier statute, she unequivocally admitted that even though she's required by law to maintain these logs, she's also required to verify them and certify them. She verified and certified false logs, and she admitted that it was a violation of federal regulations. And as the court pointed out with Exhibit C of our affidavit, or Exhibit D of our motion for summary judgment, she shouldn't have been on the road anyway. It's a clear violation of federal motor carrier. And had she not been on the road, then our clients would have been behind that flatbed trailer, who actually did take the proper evasive action. And the jury can hear all of this and watch these videos and make that determination. But Your Honor, that I just wanted to keep it brief for you, but at this stage, the evidence is clearly there, and we believe the motion should be denied.
Mr. Finley. Ms. Corbach, I'll give you a quick response.
Okay, thank you, Your Honor. Quickly to respond, I would like to respond to the mischaracterized and misrepresented evidence attempts. First, regarding any evasive action by Amber, there is no evidence whatsoever that Amber could have taken any evasive action and prevented or avoided the injuries that resulted in this accident. It's only pure speculation from plaintiffs and interveners' arguments and Mr. Grill. But in fact, plaintiffs and interveners conveniently leave out the deposition testimony by Amber, where she specifically stated, as an experienced commercial driver, she did not have enough time or space to take any evasive actions. In addition, when they refer to the flatbed tractor pulling over onto the shoulder, that is after the explosion and the accident behind it has already occurred. Secondly, Your Honor, their own argument hurts themselves. They are arguing that Amber was negligent because she failed to take evasive action, but Miss Little behind Amber didn't take any evasive action. So if Amber is negligent for failing to take evasive action, then so too is their own client, Alice Little, for also failing to take evasive action. Thirdly, Your Honor, I'd like to briefly review the logs because they've been mischaracterized and misrepresented. The Federal Motor Carrier Regulation governing the hours of service is Rule 395.3. This rule sets out the hours of service that are applicable to commercial drivers. Specifically, in an 8 consecutive day period of time, a driver can have no more than 70 on-duty hours. After a driver has incurred 30 in an 8-day period of time, after that period has passed, if a driver encounters 34 or more consecutive off-duty hours, their hours of service are reset and the slate is wiped clean and starts over. So let's look at Amber's logs on August 18th. If you would please pull up the log from August 18th. On August 18th, you can see Amber's logs. To the right, it shows the drive time, the on-duty time, and the total hours for the day and the week. You can see in the blue line in the graph, there is a 13-hour and 54-second consecutive time period where Amber is off duty. If you go to the next log on August 19th, the logs show that Amber had a consecutive 24 hours off duty. This consecutive 24 hours, in addition to the 13 hours and 55 minutes from the day before, restart because that is over 34 hours. Accordingly, her hours of service have started over, the slate has been wiped clean, and we are on a new 8-day consecutive period of time. That is why the argument for her prior week's 8 days logs is irrelevant and a red herring. On August 19th, 20th, and 21st, the logs demonstrate that Amber was nowhere near violating the hours of service time for either her drive time or her on-duty time. Here's the August 18th, the August 20th log. As you can see, her drive time is 8 hours and 3 minutes and 26 seconds, and her on-duty, not drive time, is 1 hour, 1 minute, and 32 seconds. Her total on-duty time for the new 8 consecutive day period is 9 hours, 4 minutes, and 58 seconds. Nowhere near an hours of service violation. The log for August 21st, 2018, the day of the accident, for August 21st, it demonstrates that she drove 1 hour, 27 minutes, and 18 seconds. Again, considering the logs that are relevant after the 34-hour restart period of time, Amber is nowhere near violating the hours of service for drive time or on-duty time. There is simply no evidence in regard to these allegations regarding the logs or any evidence that Amber could have taken evasive action that would have avoided the ultimate injuries plaintiffs and interveners sustained from being rear-ended at 63 miles per hour by a tractor and trailer. We again ask that this court grant defendant's motion for summary judgment.
Thank you, ma'am. All right. Let's go off the record. As you are aware, I've still not gotten through everything from last week. And I've got fresh new literature that y'all sent over to me, and quite a bit. I got the nice notebook yesterday afternoon. Let me just tell y'all, I am attempting to get back on track with jury trials. I am meeting with OCA tomorrow morning in an effort to clear my court to move forward. So the good news for y'all is y'all can move forward. What I would like to do, just so y'all are aware, as you know, I've got quite a few criminal cases that are over a year old that are going to be sitting at the top of my docket. But right now, y'all are set at October the 26th. That is one of the dates that I am preparing to get clearance from OCA. I have one criminal case set that day, just one. My attempt is to get that one tried. I will tell you, I still think it's a coin flip whether it pleads or actually goes to trial. So that being said, there is a very good chance, probably the highest that it's ever been me talking to y'all, that y'all could go to trial on that day. All right. So I want to make sure y'all understand that, we could get this thing over with and y'all could quit meeting with me on a weekly basis and we could move forward. So I will know by tomorrow afternoon whether I get that clearance. I'm asking for September 21st, October 26th, and December 7th for me to be able to have in-person jury trials, with the pick being in this courtroom. Obviously, that is a logistical nightmare, but I'm going to run through my plan with them, and hopefully they give me the okay. So I just wanted to give y'all a heads up on that. I know y'all are probably kind of banking on that I wouldn't be able to get that done, but it does appear, they may tell me no way, but I am going to try my hardest to be able to get a trial in here in about 3 weeks. So y'all just keep that in mind. And then the next date would be y'all's date that I'm asking for. And y'all are going to be the only civil case that I keep. So there will be 2 cases and 2 cases only on that day. The other one is a aggravated sexual assault. It is habitual, so it is an auto life case. Usually in those, if there's something besides auto life on the table, those sometimes get taken and they go away. So I would say it's a coin flip whether or not a plea gets done on that case. So please don't think that the criminal cases, that's the only case that is going to be in front of you. And it is I think Judge Drum could tell y'all those could usually go fairly. If there's anything on the table, sometimes those are taken. So y'all just be aware of that. All right. If that happens, what I will do, if I get clearance, y'all will be getting an email, because right now y'all currently do not have a, and usually on y'all's, I don't really do a live in-person pre-trial type deal. It will be just basically a trial announcement date that y'all would have to give. Usually that would be this week by Friday, because I usually have to order the jury, but I'm going to order one anyway. So I'll give y'all, if y'all get an email from me tomorrow afternoon, or at least from the coordinator for tomorrow afternoon, we will probably have a trial announcement a week from Thursday, just to make sure we are good to go. And I've been pretty patient with letting things be pushed back so far. If I got a date, I'm going to do everything I can to get it. If I'm bringing in people, we're going to try a case. All right. All right. Any questions on that besides any procedural questions? How about that?
None from plaintiff, Your Honor. Thank you for that information.
Yes, sir.
None from the interveners, Your Honor. Just one thing that I would let the court know, and I think all the parties would agree with this, is if we make a trial announcement on September 3rd, we also have mediation set up on September 11th. And so, maybe the case goes away at mediation as well, but we will go ahead and make that announcement on the 3rd as well, for sure.
Okay, that's fine. I just do it that quickly just because I'm not like Dallas County where I have a central jury room and people coming in constantly. If I order a jury, it's for one case. So that's the only reason I do it that early. All right.
And Judge, you said that you would hear back from the OCA tomorrow, so we will know at least that information tomorrow.
I'm meeting with them tomorrow. This is going to be number 2 right now, 2 on October the 26th behind Dominguez. I told them you will let them know whether OCA gives me a yes or a no.
Thank you, Judge.
Sonny will just send out an email to all of y'all and say, it will say we are good to go. But I thought we'd be good to go months ago, but oh well. All right, but y'all just keep a lookout for that. And then we'll set, if that is, we'll set a trial announcement for next Friday. And she'll give you that information of what to do. And yes, we'll hopefully, I'll hear something back from y'all on the 11th though, that you are all good to go and tired of seeing me. All right.
Thank you,
Thanks,
Judge.
Judge.
You have
All
a good
right,
afternoon.
Y'all have a great day.
Thank you,
Bye-bye.
Judge.